that
There we
email from Judge Mattson. Did everybody receive that?
Yes.
Okay, it is 12:01 and we are ready to convene this scheduled meeting of the Judicial Conference's Standing Committee on Legislation. I see we have on the Zoom attendance Judge Mattson, Judge Eldweek, and Judge Clark, as well as myself. Judge Hurley may be joining us here in a bit, but in the interest of hopefully completing our review of suggested legislation, we'll go ahead and proceed at this time. Ms. Behrens, you have shared your screen, and so I'll just let you sort of orient us through the couple of items that are on our agenda today, starting with that the leaker disclosure related bill.
So we talked about last time, and then I did speak with the criminal division of the AG's office, and they were concerned about it going in 12.1.1301 because the definition of confidential information there doesn't really fit what we're talking about.
Okay.
So we talked about putting it in a new section to chapter 2701. I suppose we could do a new section to 12.1-13 if we made sure to be very clear in there what that we were talking about, court records and what exactly we're talking about, as long as everyone's comfortable with the definitions in 12.1 and their application to the court system. Because public is let's see. So the definitions in 12.104, I believe, apply. Nope, that's the wrong one. Oh, I think it's 0104.
0104, yeah.
Yep. So 0104. So government does mean judicial branch. Governmental function includes any activity that one or more public servants are legally authorized to undertake on behalf of government. And public servant, as used in this title and in any statute outside this title, which defines an offense, means an officer or employee of government, including law enforcement officers, whether elected or appointed, and any person participating in the performance of a governmental function. The term does not include witnesses.
Thoughts from the committee about where you think this provision is best located?
Well, my email was just put forward based upon Justice Tufte's comments about having a criminal statute outside of Title 12.1. But if there's more comfort in Chapter 2701, so be it. But I would also point out, in terms of those definitions that Sarah ran through on 12.10104, the language at the beginning says, as used in this title, unless a different meaning plainly is required. And so obviously, if we want a unique definition for a particular offense, and that we can be able to have that within the statute, that we craft up. But going outside of 12.1 into into Chapter 2701, we're going to lose many of these definitions unless we specifically have them included.
And I guess right now in this particular draft I came up with, we don't use those definitions. But I mean, we certainly could put it in 12.113 if we're all comfortable with those definitions and use those terms without using confidential information, because I don't think that it quite fits with that definition, which is means information made available to the government under a governmental assurance of confidence as provided by statute.
Yeah, so in the
Because we're
draft,
creating it, so.
do we need to define a pending decision as confidential information to have the effect we want here?
Yes,
I think so.
because if it's exempt,
I agree.
and right now under AR 41, the version that will go into effect, I think it would be exempt.
Right. Well, we definitely want to harmonize it with that. I'm looking at the 3 lines, 6, 7, and 8. The second sentence seems to be freestanding and not reliant on the first sentence, unless I'm missing something. It's not intentional disclosure of confidential records is a misdemeanor. It's intentional disclosure of a pending decision is a Class A misdemeanor. See what I'm getting at?
Yep.
Yep.
So I don't know what work the first sentence is doing, at least as I read this section.
So are you suggesting taking the first sentence out?
Well, unless I'm missing something it's doing connected to one of the other sections in the chapter, I maybe I'll just make my related comment now so that we can discuss it together. I'm wondering about the term pending decision. I think this, as drafted, it would clearly apply to the kind of link the US Supreme Court had where somebody disclosed a draft order or draft opinion of the Supreme Court, or any sort of similar draft judgment or order from a district court. But if you just say you had access to that information as an employee and you told a newspaper reporter what the result was going to be of a decision coming out tomorrow without sharing the decision, the written decision, is that included in this fairly, do you think? Should it be? I mean, I think it'd be good for us to talk just a little bit about how broad that the fair meaning of that term is and what we think the scope should be, because we may or may not have exactly the idea of the proper scope of the statute.
So by that, you're questioning how far intentional disclosure goes?
Well, more I'm thinking what's included in the term pending decision. So, you know, if somebody goes out and says, well, on this case that was heard yesterday, Vandewall and McEvers were voting this way and Crothers and Tufte were voting that way, they wouldn't be disclosing the, you know, the reasoning or the draft opinion or anything like that, but just sort of a, you know, if they had a bug in our conference room and they knew how we had initially discussed the case, that would be confidential information relating to a pending decision, but it wouldn't be a pending decision, I don't think.
I mean, we can add disclosure of a pending decision or information regarding a pending decision.
Yeah, and the risk there is that we draft it too broadly, and then it's, if the clerk says the decision will be announced tomorrow, we don't fairly want to include that either. It just highlights the trouble that we're not experts in drafting statutes and wanting to be careful about carefully defining criminal statutes. And maybe we've got it right. I just raise it for any further feedback before we decide whether to push this forward.
Do you feel comfortable with it in chapter 2701, Justice?
I think I'd somewhat prefer having it in 12.1 because I know we do have criminal statutes scattered throughout the Century Code, but in terms of prosecutors being aware of it and others, you know, otherwise providing fair notice, I don't think anybody would reasonably probably look to Title 27 for violations. Do we have any others, Sarah? Do you know?
In our
In
chapters?
yeah, in any of our titles relating to the courts, I don't think there are any criminal offenses defined in there.
Yeah, I'm not sure. I know there are other statutes like outside the criminal code that provide offenses, but
Yeah, game and fish and Title 14 and some of the others do.
Motor
I don't-
vehicle.
Oh, yeah.
Yeah.
Title 5.
Yeah, so there's a variety of them scattered throughout. That's probably not a big deal. I don't have strong feelings, and maybe the legislative committees would have a different view and put it somewhere else, and that's their prerogative. I think at this point, I don't think that first sentence, I don't think I could adequately explain what it does in terms of defining the Class A misdemeanor that we're trying to capture here.
Is it just meant to be that pending decisions are confidential? So that.
Yeah, I think that's what it, I think that's what it does is it
Lib-
sets the definition of a pending, well, it defines a pending decision as a confidential record. Without that sentence, whatever statutes that relate to confidential records would not be included or would not be contemplated by it. So I think it does add to the definition of pending decision. It classifies it as a confidential record. Without that sentence, it doesn't.
Except for not under this title.
I'm sorry.
Except for not under this title, all the definitions aren't included in Title 27. That's in a different title.
Well, no, I understand that, but what this sentence does is it makes pending decisions confidential records. Without that, that is not definitionally, that isn't defined.
Yeah, so what's the consequence of those being confidential records? Or is it more like a whereas clause?
Probably more like a whereas.
Is it meant to be a confidential record as defined somewhere else?
Yeah. I'm guessing I think that's right.
Could there be a reference then as confidential records as set out in wherever it's at?
well, our definition of confidential records is in AR 41.
Yeah.
And
Cool.
I don't think that the Legislative Council would allow us to refer to an administrative rule.
Could we then just put the language of how we define the confidential record and draw it off
But why does it
AR
matter?
41?
Why does it matter?
Well, for the purposes of AR 41, if we know that a pending decision is a confidential record, then for the court's purposes, AR 41 would apply.
Well, we
Right.
should do that in AR 41 if we want to do
Yeah.
that.
I do
Yeah.
think it needs to be fixed in AR 41 because right now they're exempt and that I think makes it awkward.
And that's not really relevant to making this an A misdemeanor, in my opinion. I think we could start with intentional disclosure of pending. And I'm not sure pending decisions. Would what happened with the United States Supreme Court really be a pending decision since it was only a draft order? Like information concerning pending decisions maybe, but
And there's probably some room for argument there. I think the exhibit A of what's intended to be captured by this, and so we want to make sure whatever we say here captures a draft opinion or
Yeah.
order.
yep.
Yeah, I think the first sentence is meant to cross apply to the last sentence for prosecution. I mean, isn't that the trigger for prosecution if it's not a confidential record? Otherwise, we have a pending decision as a new class. If we already have a class of records called confidential, it brings pending decisions within that purview.
Well, the courts define for our records confidential or exempt in a rule, and I wouldn't want to start down the road of by statute deciding what's in or outside the scope of our rule. I think that undoes the work we did in AR 41 if we start blending those two again. Let me give you an example of one way I read this. Pending decisions of a court of the state are printed on blue paper. Intentional disclosure of a pending decision to someone not known to have authorized access is a misdemeanor. Does it matter whether or not it's on blue paper for it to be a misdemeanor?
Exactly.
I think we can take that first sentence out, but we need to make it clear in AR 41 that it's confidential. Otherwise, you have disclosure of an exempt record possibly being a misdemeanor. I think that is awkward. But I do think it can be fixed in AR 41.
Well, but disclosure consistent with AR 41 would be to somebody authorized. Wouldn't it?
I would agree.
I would
Yeah.
agree.
But do you want pending decisions to ever be provided?
Well, district judges, if you have a proposed order given to you, is that a pending decision?
I mean, my law clerk and I do pending decisions back and forth all the time. So she's authorized to have it. She gives it back. I tweak it. I give it back to her. So
Yeah. I think sometimes you do allow folks broadly, and even the public in some cases, to have access to a pending decision. Counsel, I'm inclined to order such and such. Tell me why I'm wrong.
Well, I don't think a proposed order is a pending decision because it may not get signed. That's just what one side wants you to sign. So I wouldn't think that's a pending decision necessarily.
except Judge Eldeweek, isn't that the problem with what happened with United States Supreme Court? That wasn't necessarily going to be signed. That was a draft order.
That's quite a bit different than a council giving me a proposed order. They're hoping that I sign. That was a working draft. Apparently, I don't know
Yeah.
all the ins and outs that had been hammered out between several of the justices. I think they're two different. Those are two different animals altogether.
So if you
Although-
articulate your views on the record and order one party to submit a draft order, is
That's
that
different.
Yeah,
That's
okay.
different. Yeah.
I
No,
would-
that would be a lot more akin to the Supreme Court opinion. But what it is if I have decided I'm going to take this matter under advisement, I've made no decision or inclination whatsoever, and some proposed orders are submitted, that it wouldn't be pending.
I would agree that way from the standpoint that we're talking about an internal work product by the judge and staff, at least at the trial level in terms of justices and staff at the appellate level.
Work product is
are we not-
exempt though.
Yeah, I'm okay with some of these things being exempt. Sarah, maybe we can talk more about whether AR 41 needs additional work, but I think any disclosure consistent with that goes through a judge when it's exempt.
Sure.
And if the judge authorizes somebody to have it, it's not within the scope of this statute, is my view.
That
Let
makes
me
sense.
ask this, is work on AR 41 necessary before we tackle this at all?
At this point, I don't think so, but maybe Sarah's thinking of something I'm not thinking of. I just think we need to delete that first sentence on this.
Judge Matson, you muted yourself.
Oh, okay. So moved. I'm sorry. Thank you.
Is there a second for that motion that I incited from Judge Madsen? Thank you, Judge Madsen.
Second.
There is a motion and a second to delete the first sentence showing up on line 6 of what's on your screen. Any more discussion on that proposed change to the draft? Hearing none, any in favor, please say aye.
Aye.
And any opposed, same sign. Okay, and I would vote in the affirmative to make sure that we have 3 votes in favor of that. So Sarah, if you would revise the draft accordingly.
Yep.
Any other changes, suggestions, discussion folks would like to have, or is there a motion on whether or not the committee should submit this to the conference?
Let's submit it to the conference.
Second.
Motion Judge Matson, second by Judge Clark to add this to our list of legislation for the upcoming judicial conference meeting. Any more discussion on that? Hearing none, all those in favor signify by saying aye.
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 I will vote aye as well. And any opposed? All right, that one goes on the list, Sarah. Thank you. Next one up.
Oh, that was just the old. Okay, next is the parenting investigators legislation. Marilyn Moe had asked for some additional changes to be considered. So I don't know if everyone had a chance to look it over.
I guess I've had one or two questions, page 2 into page 3, in terms of, does this take into account that we may have the case and then we'll get it back again 3-5 years later? In terms of the language that's being proposed on the assessment of costs. And that when it talks about the cost to be borne by the county where the child resided at the time the actions commenced, if it comes back to us 5 years later and the parties may have moved. I've had that happen. I would imagine others have had that
Yep,
happen.
I see what you mean. So it would be read as the initial action and the child could have moved to a different county.
Yeah.
And I don't know the answer to that. That was existing language, the county where the child resided at the time the action was commenced. So,
But the
oh, I
language-
see. They wanted that taken out.
yeah.
I see what you mean.
Yeah, I don't understand the reason for taking that out.
Is there a regional difference? Are there maybe some of our larger counties population wise that tend to have people moving to their jurisdiction and then the motions get filed and they get tagged with expenses they think are properly responsible to smaller counties?
Well, that may be when it's initially done, but when you have a 3-5 year gap or even a 10-year gap on stuff, why are you still limited back to where the action was commenced? Yeah, I'm sure that others have seen that. I've experienced
Yeah.
it. We really have it with Air Force related, but I don't think that's the only example out there.
And I
No,
don't think,
we have I'm sorry, go ahead.
oh, I was just gonna say, I don't think that was contemplated. So you can certainly, if that part of the sentence needs to go back in, then that's doable.
Yeah,
I think it should go back in.
yeah, that is we see that quite a bit too with our transient population. We end up having folks from all over, and so the question I have on this particular section here too is the part taken out about the cost of such investigation between either or both parties? Is that provided for somewhere else? Is that why that's taken out, or is that surplusage?
It's provided for elsewhere,
Okay.
and it's contradictory.
Well, if the committee's desire is to restore page 3, lines 2 through 3, I would entertain a motion to that effect.
Judge Clark had mentioned it, so I'll second her motion.
So moved.
Okay, that was out of order, but there's a second and a motion to restore lines 2 and 3 that are currently shown as stricken out on page 3 of the draft. Any further discussion on that? Hearing none, all those in favor signify by saying aye.
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 And any opposed? All right, that one carries as well. So if you, Sarah, make that change. Any other comments on the draft?
What's the thought on line 12 and throughout that change to what the section 6.4 of the statute of adding in attorney on the guardian ad litem aspect? That's going to increase costs, will it not? Are we not free already to appoint an attorney guardian ad litem?
And I'm trying to remember if an attorney is required else. Oh, I guess it says may, well. I don't remember if it's required elsewhere, is why they wanted that put in.
Yeah, this looks like it takes it from either party to allowing the court to do it on its own motion or agreement of the parties. So it looks like anymore, either party can't petition the court. Has to be
Unless they
either an
agree.
agreement. I'm sorry.
Unless they agree.
Yeah, either has to be an agreement or the court's own motion.
No, it says or by motion or agreement of the parties.
Oh,
Oh,
or by motion. Yeah, I see.
is that just language cleanup or?
So,
Either
I think-
party?
Does this
Yeah,
take
'cause
away authority to appoint non-attorney guardians ad litem?
It would, yes.
Yeah, okay.
That would have an impact on the counties, would it not? Or
Increased
is-
cost.
I think their concern was that a lot of the lay guardian ad litems were being appointed and they didn't really know what to do. If I
So.
remember
so
my
we-
conversation correctly.
So then we make a sweeping change because some don't know what to do. I mean, are we saying that legislation should go to the lowest common denominator?
Spoken
Well, yeah,
like a
I mean,
former
here-
legislator.
Yeah,
Oh.
to your point, Doug, I mean, that, I think that's, you make a good point in as much as, it may be that's who we have available to us. Is a non-attorney guardian ad litem.
Yeah, it is taking away a whole.
I can't remember, do attorney guardian ad litems need to be rostered and have extra training or is it
Yes,
okay?
I believe so. Or is that just parenting investigator?
Well, that's what that's what I was wondering is I can't remember if on an attorney guardian ad litem if you needed that or not, but whatever the case, if you do need to be rostered, I'd like to know how many are available and what their distribution is throughout the state. So we kind of know if there are an abundance, I'd have less of a problem.
Well, they have a roster of attorneys that do mediation, especially on the family law side. Do they not?
Yeah, mediation, I believe that's correct, yes.
Would this be in those guardianship cases too? A guardianship after termination? Because it's an action where parenting rights and responsibilities concerning the child is contested?
Well, guardianships have their own statutes that require I need to look.
Rule of Court 8.7 says the guardian ad litem under a particular statute must be an attorney.
Okay, I was thinking it maybe was provided elsewhere is why that was done.
You have to have 18 hours. The attorney has to have 18 hours of guardian ad litem training.
Thank you for that.
Because some of this was to make the statutes more in line with our court rules, so there's not discrepancies there.
Yeah, so this looks like it's just to harmonize with that rule. I put it in the chat if anybody wants to take a quick look.
Sorry, it was a while ago that I had the conversation with Marilyn about some of this.
Well,
So-
yeah, in light of that, if that rule of court says that, which I trust it does, I haven't looked at it yet. That would
So-
be, go ahead, Doug, sorry.
Excuse me, Judge. What I'm wondering about then, yeah, well, we harmonize it, but can we also put in, include language of a lay guardian ad litem? Would that take it out of sync?
I don't know what you mean.
Well, before it's the was language of appointment of guardian ad litem. And now we're making it an attorney specifying that it would have to be an attorney guardian ad litem. Can it be an attorney guardian ad litem or a lay
Or-
guardian? Yeah,
Yep, I understand.
Yeah, so right now the statute applies to both lay guardian ad litem and attorney guardian ad litem. And the rule says to qualify as a guardian ad litem under that section we're looking at, a person must be an attorney licensed in the state. So it seems like our rule further narrows the statute in a way that this proposed bill would also narrow it in the same way.
So it just harmonizes it.
I think so. It's asking the legislature to follow our lead on what we did in the rule.
Okay.
That first sub A qualification is what I was looking at.
Oh, sure.
Yeah, that's what the rule says, so.
It is.
so I suppose we can ask what happens when they say, nah.
Well, our rule still applies, right?
Yeah.
Okay,
Yeah, I think the legislation, when it provides probably the very lowest common denominator, and the court can make rules, and it has made a rule, says it has to be a lawyer. I guess it can further narrow that requirement.
right.
And you can see the roster on our website too. I don't know how many are on there, but there's a fair number. Maybe 40 or 50.
Okay. I understand on that, so I have no more comments there.
Okay, other comments on the proposed revisions in this draft?
And I
We-
split 6.4 into sections, so because it was one big section, and to follow, to kind of mirror the previous section, seemed like it should be split up.
All right, what action would the committee like to take on this draft? If any.
Well, with the one change that we recommend to the conference. And that one change being on page 3, restoring lines 2 and 3.
Okay, we
That's
have
a
a motion.
motion, I'd second it.
We have a motion and a second to recommend this draft as amended by the previous motion to the conference for its consideration. Any further discussion on that point? All those in favor signify by saying aye.
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 And any opposed? All right, that one is approved by the committee for consideration as well. And what's left, Sarah?
Competency. This is the one that was sent to us.
Oh, right. That came up on one of the court's conferences and wanted the committee to take a look at it. Did you have a chance to, you drafted this, is that right, Ms. Behrens?
I mean, I drafted it with what the mental health work group wanted done.
Okay. Is there any background information that work group discussed that might be helpful to the committee that you can recall?
I mean, I think it's all pretty much contained in this summary that's in this letter.
Okay.
Right now, the way it's working, the timing is really odd, so that sometimes B misdemeanors are sitting longer than felonies, and much longer than the time that they would have sat in jail. So it's the A misdemeanors are provided more time than someone with a felony, so they sit longer. So this fixes that. And then B misdemeanors, the longest they could serve, I believe, is 30 days. So they're basically can have that whole 30 days trying to restore competency. So other than the 12.117, the proposal is to just dismiss those B misdemeanors if they're not competent, rather than trying to restore competency for a B misdemeanor that would be their sentence anyway, if that makes sense.
It does.
Yeah, it
What's
does.
gonna track this, Odyssey or?
As far as
In a jurisdiction like Cass or Burley, if they have 50 B misdemeanors that are seeking competency, what's going to trigger the 30 days? Just the setting of a status conference or?
Well, so what happens is, so you have a B misdemeanor and there's a question of competency. Right now, they're sending those individuals to be restored, and it can be for 30 days. So they've got a suspension of the proceedings for 30 days.
30, okay.
Well, within that time, I mean, basically they've sat as long as they would serve jail time.
Yeah.
So it's clogging up the state hospital with these B misdemeanors that the proposal is they should just be dismissed, rather than trying to go through all this restoration of competency for this short period, it's the short sentence time, except for 12.117, which I believe is domestic violence.
So you have defendants who are violent, committing assaults, and we just dismiss them if they're not competent and don't try to get them mental health treatment?
Well, I don't know that they're
not getting it anyways.
I believe there are other options that we're putting in, so that other options can be looked at rather than just
Under the other options, can't they be done already in
they
terms
can
of
be committed. Yes.
a civil commitment, an alternative
Correct.
outpatient?
And
Yes.
note it says except misdemeanors under 12.117, which is the assaults.
Okay.
Yeah, I reviewed this, and this is somewhat similar, I think, to a Minnesota procedure, if I recall correctly. I think this is the correct way. I would even, with respect to 12.117, if it's a Class B misdemeanor, I don't even think it should be stayed for under that, because the reality is this is a Class B misdemeanor. I'm not saying they can't be serious or that there's not a there's not some mental health issues to be taken care of. But I don't think sending somebody who's charged with an assault to be restored for a Class B misdemeanor assault as either best use of resources. And I don't know why that should be carve out particularly. They're not competent. They're not confident.
I can tell you why it is. The thought is that it's more likely to be accepted if those violent charges are carved out, and we may receive less pushback from the state's attorneys.
Yeah, I can understand that it is a compromised position, but the reality is that's all it is. It's to ameliorate some pushback, and it's not based in sound policy in my view. But I understand it as a compromise as such, and I would accept it as written if it meant that it is adopted.
And at this, maybe I should offer one more comment on how this got to this committee. So as you saw in the materials, there's a companion rule that was provided by Judge Cruff in the mental health work group. And that was submitted to the court for the court's consideration of both the legislation and the rule. And since we have this committee that reviews legislation, I don't want to have two tracks where the court suggests legislation and then this judicial conference committee on legislation also suggests legislation. So our policy oriented review, the committee can do what it likes, but we might take the view that this has been vetted by a subject matter expert group, and provided we don't see any significant red flags that were overlooked, Judge Cruff and that work group can probably offer any arguments in support of it to the judicial conference. And then I think that rule that was provided with this would be considered by the court if and when the statute or the bill is passed. So, or we can take any approach the committee would like, but at least that was my initial suggestion was, if we put this on our list, we invite the work group to explain it and make their case for why the conference should push it forward.
Yeah, I think they did a lot of work on this, and I like it. I just, that the assaultive, where there's victims, troubles me, but I think it's encompassed in paragraph 1. So I agree with Judge Tufte.
So would the committee like to include this on the list or not? What is the will of the group?
Move to approve.
Second.
Motion, Judge Eldweik, second, Judge Clark, to include this in our list of proposals for the judicial conference. All those in favor signify by saying aye.
Aye.
And any opposed? Hearing none, this one is also approved by the committee for consideration at the next meeting of the judicial conference.
Yeah.
Is there anything else for consideration by the group today?
That was all that we had left.
Okay, any new business by any members of the committee?
Oops.
And Ms. Behrens, do you have a handy list? Can you just tick off what at our last couple of meetings we've approved and what will be in the materials submitted to the conference?
So in addition to what was approved today, there's the restitution bill, small claims, summary dismissal and disposition, open meetings, once in jeopardy, and the temporary court of appeals.
Okay, and you'll be putting those together. Do you have a deadline for that for court administration?
I was not given a deadline yet, but I mean, it's coming up on the 21st, so I'm sure Renee will let me know when she needs the stuff by.
Okay, the 21st of October?
November.
Of
Sorry.
November, okay, thank you. I was worried there for a minute. All right, so if you would just, once you put those materials together, I think I would appreciate an advanced copy, maybe a day or two before you submit it, just so the committee can see it. And if there's any last minute, something one of the committee members spots or thinks was omitted or something, we have a chance to offer any objections or additions before it's submitted for the conference.
Okay.
Thank you. Anything else from anyone?
Nope.
No, I don't. I'm glad, just Tufty, we were able to get through this. Thanks so much.
Yeah, thanks for all the time you're all putting into this, and I think that this is the committee had been just 3 members for a couple of years, and we've been able to do well, I think, but the new membership that we've had, despite Judge Hurley's continual snubbing of our group, I appreciate the new energy and attention that we're getting here. So thank you to Judge Clark and Judge Eldweek for your contributions.
Thank
I
you.
agree. I agree. Thanks so much.
Thank
All right.
you.
We are adjourned.